Published various works on both constitutional and commercial law matters and delivered papers on the Philippine commercial system and the Philippine insolvency system before international fora. Both my private and academic work have been primarily geared towards the rule of law regime, particularly in evolving a commercial law system that treats of the operation of common law statutes within a predominantly civil law system. Your Honors, I am the product of the public school system, having taken up my elementary education at the Santo Rosario Elementary School in Angeles City, obtained my high school education under the tutelage of Belgian priests in the Chivalrious School, and I obtained my college degree from the Holy Angel University, magna cum laude, and eventually became a member of its Board of Trustees. I am essentially, Your Honors, a provinciano, having left Pampanga only at 21 years of age to take up my law studies at the Ateneo, where I graduated valedictorian and cum laude. I continue to go home from my work each day to Pampanga. I am married to my college classmate, Arlene Sicanco, who is now the president of the Holy Angel University, and we have 3 children. Our eldest and only son and my other daughter are both lawyers. I am a lolo, with my first grandson being born to our youngest daughter 2 years ago, and we are expecting our second grandson to be born to our older daughter sometime in November of this year. By way of ending, I share my personal philosophy of the law. For me, Your Honors, the law constitutes the very essence of man's civilization. It represents the mind, the heart, and the soul of every society. Leading members of society set out a set of precepts, rules, and regulations which they consider important for the members thereof to live and grow in a civil fashion. That is law as the mind of society. For the individual members of that society, the law assures them of the power to determine the course of their lives, to seek fulfillment and happiness for themselves and their families, consistent with those of the desires and dreams of their neighbors. That is law at the heart of society. And finally, the law provides for them the means by which society can protect and nurture some of its weakest and most marginalized members as its primary expression of the collective duty to a higher being. That would be law as the soul of society. In all these 3 aspects, the law therefore epitomizes the ideals, the virtues, and the actions of a civilized society. Thank you, Your Honors.
Attorney Cayusa, please.
Thank you, Mr. Chairman. Before I propound my questions, I would just like to make it of record and disclose that Dean Cesar Villanueva was my professor in sales at the Ateneo Law School. Good afternoon, Dean.
Good afternoon, Your Honor.
You were recommended by, among others, the Philippine Trial Lawyers Association, and they come here in full force. What encouraged you to give your conformity and to be considered for the position of Chief Justice?
Well, first and foremost, I think our nation in general, as well as our judiciary in particular, are at a crossroads. The vacancy has been created through an impeachment process that have fitted many of our great institutions. And therefore, men and women of goodwill in this country ought to show that they believe in the process, in the selection process. And therefore, when I was nominated by the Trial Association, I thought it was an honor for them. It was an honor for me to honor such nomination and participate in the process, to show that it is possible to continue, for democracy to continue to march on, especially in one of the most important branches of judiciary, of the government, which is the judiciary.
You have been in your current position for, as you mentioned, just almost a year. Now, what made you decide that this would be the proper time to maybe change course, because you have always been involved in commercial law, and in the judiciary it will be a completely different orientation? Why this at this point in your life?
Oh, basically because I believe that the Supreme Court, as it fashions out and explains the precepts by which our society moves on, and on the constitutional mandates, economic mandates, I think that being part of the Supreme Court and molding the decisions by which to look at and update the commercial law principles of our country as they are connected with constitutional precepts is an important task. And I had even my works, Your Honors, have always consisted of looking at how the Supreme Court, through what I call judicial activism, has been able to move on to international standards, the commercial law standards of these countries, to allow us to compete well with the rest of the world. So the Supreme Court, through its precedent-setting powers, is at the cornerstone of that great process, Your Honor.
Notwithstanding the fact that you have only been in government for less than a year, what have you set out for in the judiciary, particularly with respect to judicial reform? What do you propose would be the bedrock of a Villanueva Court?
A Villanueva Court is one that looks at the end of that term, if it comes to pass. You would see a Supreme Court that has allowed itself to be shown to the public as a great institution that has worked cooperatively with the other two branches of the government towards fulfilling the wish of our people for a just and humane society. And a judiciary constituted of dynamic, competent, and well-motivated judges and their staff spread all over the nooks and corners of this republic in the various courts, that they become the face of the republic and the very epitome of judiciary, so that the common tao would see that indeed justice is accessible to them, it has a face, and it is demonstrated. And more importantly, a legal profession that is so motivated, considers itself every day of their existence to be truly quasi-public, if not public officers, but officers of the court, who will, in their daily task before the courts, in protecting their clients, are able to show that it is possible for our profession to be at the forefront of achieving a just and humane society. And that is all achieved by a Supreme Court that exudes the very foundation of what we call a just and human society through its procedures, through its decisions, and through the actuations of its very 15 justices, Your Honor.
Thank you, Dean. You have been part of molding the legal careers, I would say, of many of your students, this included. In fact, I would like to tell you that a great deal of style in instructing my students in law school, I derive the inspiration from your own style. But let me get to my next question with respect to legal education. You are still, I suppose, with the MCLE board?
No, I made sure that when I joined the when I accepted the chairmanship of GCG, I tried to make sure that I would be concentrated fully. So I gave up my other positions in government, even in those on a consultative basis.
So, but having served the MCLE board for many years, well, and also you mentioned that you have been in coordination with the Legal Education Board. There's one concern here with respect to the function of the pleb in connection with the MCLE. Is there any apparent conflict in the promotion of continuing legal education with the functions of the PLEB and the MCLE?
We do not see any conflict, Your Honors, simply because the LEB is actually in charge of legal education in this country for those who are still under bar, basically those who are taking up JD or LLB, but including now those who have already a license but want to upgrade their curricular norm by taking up an LLM. So it is the academic side of trying to mold the minds and hearts of what we call future lawyers. On the other hand, that would be LEB. On the other hand, MCLE has its focus on those who are already in the legal profession, ensuring that they continue as they strive towards fighting for the causes of their clients, or protecting the lives and properties of their clients, that they continue to keep themselves abreast with the latest legal developments, so that the legal profession as a whole is one that is not only that is competent, but has integrity in the manner by which it discharges them. So these are two institutions that look at the various stages in the legal development of those who would become or those who are already lawyers in our country, Your Honor.
With the current requirements under MCLE, do you feel that there is a need to change the required subjects so that it becomes more relevant to the legal profession?
Yes. That has always been asked of us, Your Honors, when I was still in the MCLE governing board. I think that what has happened is that after the first wave, when the providers started to put together this various MCLE program, that when the second term came about, they were still doing the same thing. I think it's important for MCLE to reach a point where there is a grading system, a graduation from basic to more modern providers. And I think that by requiring MCLE providers a program by which to allow those who have already taken their other courses to get better courses or graded courses, then it would be more relevant, Your Honors. The other thing, Your Honors, is that because MCLE is just graded on the amount of time that you spend in the lecture room, some of them actually just sleep through it. So the request of many lecturers is that we ask those at the back not to snore too loudly. And because there is no responsibility being imposed, Your Honor, I think that perhaps for them to take more seriously the fact that they have to learn something from the lecture, in spite of some of the lecturers, perhaps what we did in the Filja would make sense. That at the end of it all, they will have a short quiz just to determine how much or how well they have taken to heart some of the teachings that they have. Those are the things that I would look at in the MCLE, Your Honor.
Thank you, Dean, and I agree that those at the back have to snore less. Moving on now. One of the concerns is really being able to gauge the performance of the members of the judiciary. What would you propose would be a good way of gauging the performance of our judges and even our court personnel so that we can determine whether they would merit a promotion?
That's really good, Your Honors. First of all, the Filja, which is the education and training arm of the Supreme Court, should be empowered really to be able to ensure that only those who seek appointment in the judiciary should undergo their training program. But more importantly, Your Honors, the Filja undertakes every year an annual upgrading of judges and members of the judiciary all around in several regions. I think that what has to happen is that that would have to be upgraded in the sense that they would have to take courses. The judges, in order to seek promotion, and if this is respected by the JBC, must be able to go into a graduated training that will make them be qualified for greater. There must be merit in what they do. The other area, Your Honor, would be for the Filja to actually be able to divide the training that it has from centered at Padre Faura, to be able to divide them into regions, because each of the judicial regions in our country have different needs. We found that out. And therefore, if a Filja is able to regionalize and develop programs that allow the judges and their staff and to be able to get into trainings that would go into that would be a great work towards doing that, Your Honor.
For my last question, Dean, well, there has been this talk about outsiders, insiders. First of all, would you consider yourself an outsider? And second, do you think that the so-called insiders would have an edge over the outsiders as to being in the capability of the work that is required for the position of Chief Justice?
I don't consider myself exactly as an outsider, Your Honor. I have been involved in the Academic Council of Filja, and in many of the projects that we have undertaken with with the members of the Supreme Court. Therefore, I have come to know and worked with many of the incumbent justices of the Supreme Court. Some of them as members of the Academic Council before their promotion to the Supreme Court, and some of them as members of the faculty at that point. So many of them, they know me personally. I know them personally. So I'm a person who does not come outside and unknown to them. Therefore, if I do come in, Your Honor, it would be easy for me to work with them, as I hope it would be easy for them to work with me. But more importantly, Your Honor, on the issue of whether an outsider can do the correct work, we realize that the vacancy that has been created in the position of Chief Justice has been through an impeachment proceeding, as I said, that has fitted the three institutions in our society almost against one another. And perhaps at one time, the Supreme Court, I suppose, versus the two other branches of the government. And perhaps getting an outsider to work with the current members of the Chief Justice would be what the Supreme Court needs right now, especially an outsider who is not a stranger to them, and therefore especially an outsider who comes from the executive and can relate to them that matter, Your Honor. And in the end, perhaps that's what the Supreme Court needs right now, and perhaps that is what is needed in order to mend, so to speak, the relationship between the three branches of government, Your Honor, somebody who is from all of them. And therefore, an outsider like me would work with them and cooperate with them, not as to be superior, but the first among equals, and to be able to work well and how to allow the Supreme Court to be able to do its job better, especially in relations to other branches of government. The other thing, Your Honor, is that really when an outsider gets appointed into the Supreme Court, at that moment in time, he's really no longer an outsider. He becomes, at that point, truly one of the insider. And all of his being and the resolution that he has are all towards being able to work out very well with his colleagues in order to strengthen an institution that I'm sure that every one of those 15 justices love and care for, because it is the fulcrum of our democracy.
Thank you, Dean. With that, I wish you luck.
Thank you, Your Honor.
Thank you, Mr. Chairman.
Attorney Mejia, please.
Thank you, Mr. Chairman. Good afternoon, Dean Villanueva. For starters, I have two related questions. The first is, at what point in your life, or more specifically in your professional life as a lawyer, did you entertain the thought of becoming a Supreme Court Justice? And the other question is, just how passionate are you in becoming one?
All right. I think that what attracted me to being to the position of a justice of the Supreme Court was when I started to work as a member of the Academic Council of the Philippine Judicial Academy. There we began to interact with the justices of the Supreme Court, also justices of the Court of Appeals, and you could see that within the Supreme Court and the Court of Appeals, some of the best legal minds, some of the best Filipino patriots that you can see. And working with other judges, trial judges, you also see some of the great heroes that are there, where they dispense justice, in spite of the fact that they work under conditions of privations. And yet, every day, in spite of the temptation, they try to dispense justice. These are people who, I would say, carry the face of the Republic towards being able to, they could have had options. Some of them have graduated from some of the best law schools, but they continue to be there because they believe in justice. That was the time when I said, it's really not a bad job. It's a job where after doing it well, you would say at the end of your life, I had made it, life has been meaningful. That's when I began to see the attraction for the judiciary, Your Honor.
Thank you. What is your vision of the Supreme Court? Should you become the Chief Justice?
Well, my vision of the Supreme Court is what I read earlier, that it becomes more than just a trier of facts, more than just a constitutional court, of which it should be. That's the most important thing. It fulfills that job. But it becomes truly one of the three main pillars of our republic in being able to usher in the good life for our people. That it becomes a critical and yet interdependent member of the triumvirate. In other words, it does not It is not at the forefront of trying to promote economic development here, because that's probably the main job of the executive and the judiciary and the legislative. But it does guard the precepts that are there in the Constitution to ensure that as we struggle towards development in this country, changing the lives of our people, that the programs do follow the economic policies laid out in the Constitution. I believe this is important because we have many complex problems here brought about by lack of good education, by poverty. And we know that many of these would be unlocked if we begin to have economic development in this country. How can people ask for democracy if they are starving? These are the finer things that only the middle class and perhaps even the well-off can take advantage of. So being able to move many of the members of our society towards a better economic family existence would usher in solve many of the problems that we have in this country. And the Supreme Court could be at the cutting edge of that, Your Honor.
What would be the immediate problems that you expect to encounter once you assume office, and how will you deal with them?
The immediate problems I see is that first there's an issue of whether what interest I represent. Do I interest coming from outside, as they say? Do I represent the interests truly of the Supreme Court? And the next item is that how far will I go? I think that sometimes I think that my reputation has preceded me in that I mean what I say and I do what I say. That's also the same principle that we have adopted in the Governance Commission. We will not ask of the boards of directors of GOCCs what the Commission itself cannot do. And therefore, if we ask of them good governance, we must be 1,000 times better than just being good governance. And therefore, I think it's the sweeping changes that may be demanded of, the accountability that may be demanded of, that are the changes. But I think that many members of the Supreme Court who know me personally would be able to know that as I've worked with them, we only have everybody's good intention to resolve, all consistent with trying to build a better republic. I think those are the change that probably they expect to come.
There is, and I am now starting to read from the suggested questions from the public, there is jurisprudence which in essence states that the mistake of the lawyer binds the client. Is this not an unfair ruling?
It probably is, Your Honor, but in the end, that's how important the role of every lawyer is in society. They are the ones who have received the training. They are the ones who have received, in fact, a license from the Supreme Court to represent a client's interests. And therefore, the clients must be able to choose their lawyers very carefully, because in the end, the mistakes of the lawyer become their own. And the problem with that, Your Honor, is that some lawyers will make a mistake, some of them intentionally, some of them maliciously, and it just ruins the entire profession. It ruins the reputation of all the other lawyers who daily try to find their way towards achieving justice for the member of society. And that particular point, therefore, emphasizes the strong role that lawyers play in our society. And we see that, Your Honor. You may not, when one becomes a lawyer in the family, he need not be the eldest, and the whole clan turns to him for advice, even the kuya. And the same thing in our society. The lawyer tends to be derided, but people in need always feel that the best defenders of their cause would be a lawyer, because he has the training. Therefore, that the upliftment of the profession is such an important aspect of development, Your Honor.
Thank you. I will now read the last two questions that I intend to ask as inputted. The Supreme Court Justice is expected to handle all sorts of cases. Is not your specialized expertise in commercial law mean that you have limited knowledge of the law?
No, Your Honor. In the end, I think it is important for professionals to choose an area that will animate them, that will impassion them, that will enchant them so that they become the best and the brightest. But in doing that, as they say, the law is always interrelated. In fact, many of the principles in commercial law have to do with contract law. They have to do with constitutional law. And in my search of being an expert in commercial law and corporate law, I have always had to deal with the policies, consideration behind them, market forces, and more importantly, the writings do indicate that I have to consider the constitutional basis by which certain commercial law principles are there. So it has not been. And I've also been engaged in litigation all my career. In the latter part, it has been corporate litigation. So it is not true that by being one of the, by trying to become one of the leading minds in commercial law, one is completely oblivious of the other areas of discipline. It is not so. Because if it were so, then you really are not a great mind in that field, so to speak, Your Honor.
For my final phone-in or tweeted-in question, what is your position on fraternities? What advice will you give law students with regards law school fraternities?
All right. One of the problems I've had when I became dean of the Ateneo Law School was, in fact, fraternities. I belonged to one, and I knew that one of the greatest challenges and the measure of how I've been a good dean is whether I could live beyond fraternities and association. So one of the things that we made sure was that to get out the message that if you're a fraternity abroad, then it does not give you an advantage. In fact, it gives you more disadvantage. Because you swear that excellence is your aim, then you have to prove that. You have to be better than the next one. But more importantly, we made sure that the rules on discipline were enforced fairly, to make sure that justice is meted out very quickly, and to make sure that they are always met by people who are undoubted caliber. So, and the most important thing, Your Honor, is that we realize that fraternities in almost all law institutions are there to stay, whether it be the UP College of Law or the university law schools, because it seems to be a natural gravitation of men and sororities for women to belong, to want to belong. And therefore, instead of trying to outlaw them, well, the best thing to do is live with them, but live with them in a way that you give the students fair competition. So, with the now dean of the law school, Cedric Candelario, who was then the associate dean for academic affairs, we made sure that life in the law school would have many options other than just joining a fraternity. That life in the law school, the survival and the ability to thrive is just beyond fraternity, being made a fraternity. In fact, we made sure that with the items that made you great lawyers, like mooting activities, like being part of the church group, by many other activities, the law journal, we made sure that they would see that, in fact, by being a fraternity, you miss out on the good things that would make you a wonderful person, a better person, and a better lawyer like that. The ability to be able to give them better choices. If there's a great idea beyond fraternity, then the solution was to give them a better idea and a better ideal. This is what we proceeded to give, so that it became a mark of distinction, even as when they went to practice, to have been part of a mooting competition, to have represented the Ateneo and the Philippines in international mooting courts, and to have won world championship, to have written journal articles, to have been part of the Ateneo Law Journal. Those are the things that are really badges of what makes a great lawyer. That's how they should be handled, we thought, Your Honor.
Thank you very much and good luck, Dean Villanueva. Thank you, Mr. Chair.
Justice Lagman, please.
Okay. Thank you very much, Mr. Chair. Dean Villanueva,
Yeah.
good afternoon. Your record shows, and as you have stated earlier, you are the present chairman of the Commercial Law Department of the field job.
I was, Your Honor, until I
Are you-
accepted. And until I accepted the chairmanship of the Governance Commission. I thought it was not fair that devoting all my full time to the GCG, I should retain the chairmanship of the Commercial Law Department of Philja.
So you
Your Honor.
left Philja already?
Yes, Your Honor.
When did you?
Last year, Your Honor, shortly before I assumed the chairmanship of the Governance Commission, Your Honor.
I see. Anyway, you have been involved in the PILJA. Now, what is your vision for the PILJA if you will become the next Chief Justice of the Supreme Court?
I've been involved. I was fortunate enough to be with PILJA. At the time, it rose to heights under Justice Amorfina Melencio Herrera, and then was with it when Justice Ascuna took over. And PILJA is very much respected by many international agencies that are offering reforms, and they always go to PILJA to do that. And it has been revitalized to an extent that it is truly one of the great pillars right now of the Supreme Court. Could it be greater? Of course it would, Your Honor. We were, before I left the Commercial Law Department, Your Honor, we were tinkering with being able to regionalize PILJA. In other words, we were thinking of being able to put up satellite offices and a satellite organization in each of the judicial regions in our country, and for them to be responsive to the areas that were there. We were seeing that some of the programs that were relevant to some people, some of the judges in one region were irrelevant to the others, and therefore so much funding of the Supreme Court was going into all of this training program. We wanted to make sure, therefore, that PILJA began to be important, responsive in each of the region by doing regional one, and to be able to train within each of the regions not only an organization but some of the core professors who would be known to who've decided to devote their careers in the province, Your Honor. That's one area, Your Honor.
Okay, thank you very much, Dean. Now, let's go to another point, Dean. It is given that the two political branches of government, namely the executive and the legislative, have the primary responsibility of promoting the economic well-being of our country. A former Chief Justice once said that the judiciary has a similar duty to nurture prosperity and alleviate poverty in our country. Do you agree, Dean?
I agree, Your Honor. Very much so.
Okay. Now, if you will be the next Chief Justice, how can the courts nurture prosperity and alleviate poverty in our country?
Our Supreme Court is in a unique position compared to the Federal Supreme Court in the sense that our Constitution, in fact, has economic and commercial precepts and policies.
Yes.
Therefore, the Supreme Court has often said that it is not their choice when it comes to economic policy. It's not their choice that they should have a say in it. It's their bounden duty to ensure that the economic policies within the Supreme Court are followed. I wrote on this, Your Honor, on the philosophical underpinning of the commercial law provisions of the Constitution, and I said, you notice, compared to American Constitution, our Constitution has needed to have economic policies, mainly because we're a country that's trying to find its way. We are not a developed, we're merely a developing country, and therefore it was imperative for our writers to put in what they felt were the aspirations of a nation. But I did say there that the economic terms of the Constitution are not addressed solely and alone and primarily to the Supreme Court. They're actually addressed to the policy determining bodies. And therefore, the primary role of moving this country forward, of trying to alleviate poverty, of trying to make life better for everyone, is really the primary role of the executive and the legislative. And the role of the Supreme Court is not to preempt them into this. In fact, it should look at it should consider that a determination by the executive or legislative branch of an economic program is the way to do it. And unless it really is contrary to the constitutional precepts, it should live by this. And unless there's abuse of discretion, the Supreme Court should take this. And then, in areas where the members of our society object to the economic policies of our two policy determining bodies, then it is the duty of the Supreme Court in deciding such issues brought before it, justifiable controversy, to actually find and explain if it is correct the policies, the directions, and the programs that have been taken up by the both policy determining and executing branches of our government. To me, that's the role of the Supreme Court, to work very closely, at arm's length, but very close, to work very closely at being able to allow our policy determining and policy executing branches to be able to carry out the work that they have. We must presume that our legislator, it is not just the justices of the Supreme Court who have our country's progress at heart, but primarily also the executive and the legislative, Your Honor.
Okay. In relation to this, Dean, our new constitution imposes upon the courts not only the power but the duty to strike down all acts committed by any branch or instrumentality of the government with grave abuse of discretion.
Yes.
What do you think would be the effect, or what do you think is the effect of this provision on the courts?
Well, it means that on the courts, on the Supreme Court primarily, and the courts in general,
Yes.
it means that they have been granted expressly by this new provision in the 1987 Constitution, with a bounden duty to be vigilant, so to speak, over when it comes to the exercise of powers by both the executive and legislative branches, but only when there's a grave abuse of discretion should the courts come in. In other words, they are not supposed to second guess or preempt or to supplant the policy, the determinations of those bodies. Only when there's a clear showing that indeed they have overstepped, has been abuse of discretion, do the courts come in. And that's a duty that's a very powerful. That's a very powerful duty on the part of the courts, which they must use sparingly, unless there's a clear showing of abuse of discretion, Your Honor.
Okay, Dean, let's go to another point. Corruption is one of the most serious problems in the judiciary. If you will be the next Chief Justice, how are you going to address this problem?
I think the more first of all, Your Honor, when there's so much discretion, so much vagueness in the rules of procedure in the law, that actually, and there's no transparency, that actually engenders corruption. Therefore, the rules have to be streamlined so that there's less discretion and there's more transparency towards that. I think that's pretty important, Your Honor. The other one would be non-tolerance, Your Honor. I think that when a body comes together, there's a tendency out of self-preservation to try to cross over the bad eggs because it affects the institution as a whole. I think that the public realizes that corruption in the judiciary is so bad that there has to be a clear call for it. So I think that the Supreme Court, through its justices, should work very closely with government agencies in order to monitor very carefully through the Anti-Money Laundering Council, with the NBI, with the Ombudsman, very carefully do a lifestyle checks on all of the judges and justices down the line, and to show that indeed there is intolerance, there should be zero tolerance. In the end, Your Honor, we will not be able to stamp out corruption entirely, but we would be able to control it, and we would be able to show that if you get caught, you will be prosecuted. I think that's the only way to go about it, Your Honor.
Okay. This is the last question coming from me because I still have question from the Twitter. Okay. Dean, can you tell us your top 3 priorities upon assumption of office as the next Chief Justice of the Supreme Court?
Well, first of all, Your Honor, my top priority would be basically to unite the Supreme Court, not only all the 15 justices together, but also the all those who work with the Supreme Court, many of whom have been my former students, and to be able to, what we call, do a strategy roadmap. It is my intention to confer with the 15 members of the 14 members of the judiciary, because they have been at it for quite a while. They realize the problems that are there. They know they probably have some of the solutions that are there. I have my own assessment, my own inputs. Together we will try to and do what we call a strategic roadmap for the Supreme Court as a whole and for the judiciary as a whole, and then work with the other appellate courts down the line. And perhaps there is a need to be able to solve basically the problem that is at the heart of many of the 15 justices. I've been told that they just carry too much in their dockets, almost inhumanly loaded, that the other thing of moving forward is difficult. And therefore, we will work with them in order to ensure that as much as possible, the Supreme Court becomes a constitutional court, that most of the decisions that it goes are matters of constitutional issues, and that the other matters which are not precedent setting, there's a way to be able to solve that, to ensure that as a matter of practice it is limited to the level of the Court of Appeals. And having deloaded them in that case and only concentrating on important cases, Your Honor, perhaps it is only fitting that each of the justices become responsible for a judicial region. But for them, they will show the face of the Supreme Court in each of the judicial region and do a good job at making sure that the dispensation of justice goes well, that access of the poor to justice goes well, that declogging goes well. The other would be, of course, Your Honor, trying to see how the various programs that are in place towards declogging the workload of our judges and justices and judges is done. So much has to be done. And I think that this will be resolved by the third item of being able to recruit the best and the brightest. There are many empty salas right now, and I think that once you're able to attract into the judiciary some of the best and the brightest, competent, they themselves will know how to and be able to put up a stream how to handle the court dockets and work with items like ADR and JDR, Your Honor. Those are the three items that I would look into, Your Honor.
Thank you very much, Dean. Now, I will read to you some of the questions from the Twitter. Okay. Now, I will read it. Considering that the checking of the bar exams is too subjective and time-pressured due to checking 6,000 booklets in a few months, will you consider to amend the limit from 5 attempts to a new limit of 10 bar attempts? Additionally, do you agree to reduce the number of bar subjects to 3 or 4, just like in the U.S.? This is from a certain Tads Bentulan.
All right. No, Your Honor, on the reducing of the bar subjects, I think that this has gone through so much genesis and study. I would maintain them. I think these are the 8 areas where it is important. In fact, I would go with trying to ensure that judicial legal ethics is spread throughout, as is the plan, I think, of the current chairman of the bar exam, to make sure that an integral part of each of the substantive bar subjects would carry application of ethical standards. No, Your Honor, I think that the Supreme Court, once it makes a decision, we presume that the Supreme Court has made a well-considered decision. And when it issued the memorandum circular saying that from here on, it's 5 attempts, you're out, I think the Supreme Court should stick with that, Your Honor, because it doesn't do good to the integrity and the reputation that the Supreme Court changes its mind on that, Your Honor. I think that if you've had 5 bar attempts and you haven't quite passed it, you'd be doing yourself and society better if you go into other things where you will shine. I think that's the important career point there, Your Honor.
Thank you, Dean. This is another question. would you agree to my proposal that this is also from Tad's Bentulan, would you agree to my proposal that the justices of the Supreme Court should have the same allowances and salaries as that of the central bank governor, who has high salary and allowances to prevent corruption and to elevate the economic dignity of the judiciary?
I'm not aware of the salary standard of the Bangko Central governor. It probably is very high. But I would say this, Your Honor, I think that judges and justices should be well paid. I think that if we want quality justice in this country, our republic should be willing to give them quality pay. I think that we should live by the words, you put your money where your mouth is. We want our judges and justices to dispense justice in the best way possible. Therefore, give them a compensation that will allow them to concentrate on doing just that. And at the same time, be able to provide with dignity for their families, to be able to send their children to good school. I think that's important. I think it's a shame that when you look at our national budget, I think less than 1% of the national budget is given to the Supreme Court or to the judiciary. If the Supreme Court is truly one of the three important pillars of our government, then it deserves a budget higher than 1 or 2%, Your Honor. And therefore, they should all be spent towards making sure that from the Chief Justice down to the sheriff and the process server, they are paid well, and they're well qualified, they're hired well, and they're paid well, and they spend their lives doing exactly just that, being part of the judiciary. No matter what they are, the sheriff, being interpreters, stenographers, and know at the end of the day that it has been a good life, that it has been a dignified life for them and their family, and then it was a life of service to this country.
On that note, I have no more question for Dean Villanueva. Thank you very much, Dean.
Thank you, Your
Good luck.
Justice Hermosissima, sir.
Good afternoon, Dean.
Good afternoon, Your Honor.
The definition of outsider was made by our predecessors. Their meaning is that outsider is an applicant who is not yet a judge. That is what they mean. I have no objection to this, to outsiders being appointed to positions in the judiciary. As a matter of fact, the first appointments of President Cory Aquino to the Supreme Court were all outsiders, except for then Judge Amor Herrera. All the others, like Chief Justice Narvasa, Chief Justice Marcelo Fernandez, Yap, and many others. They were all outsiders under that definition. So I have no objection to outsiders being appointed to judicial positions. When Eisenhower ran for President of the United States, he went to Governor Earl Warren and said, and told Earl Warren, you help me in my campaign for presidency, and I'll appoint you to the first vacancy in the Supreme Court. Earl Warren was governor of California. It happened that the vacancy was that of Chief Justice of the Supreme Court of the United States. So Warren asked, I said, will you you appoint me now as Chief Justice? He said, no, I mean Associate Justice only, not Chief Justice. And Warren said, if you have any word of honor at all, you will appoint me, because you said the first vacancy in the Supreme Court. And so Eisenhower was forced to appoint Earl Warren. It turned out that the Earl Warren Court enunciated so many doctrines, among which was the Miranda doctrine. That is a classic in human rights. So that's that. Now, what is important really is our perspectives in the matter of applying for positions in the judiciary. Well, what is your judicial philosophy, Judge, when you become a Chief Justice of the Supreme Court?
My judicial philosophy, Your Honor? Well, when it comes to fundamental rights and human rights of people, then the Supreme Court must take, as it has taken, an activist role. It must ensure that there is no derogation at all to the rights guaranteed to our people under the Bill of Rights. When it comes to other rights, economic rights and economic policies, Your Honor, I think that the Supreme Court must take a passive role, realizing that those constitutional provisions are addressed first and primarily to both the executive and legislative department. And that, as a matter of practice, the Supreme Court should not supplant its own economic theory to those that have been pursued by way of policy determining of the legislature or those of the execution process thereof by the executive, Your Honor. I think that the Supreme Court, therefore, should primarily take the role of being a constitutional court. That, like the U.S. Federal Supreme Court, it should not overburden itself with so many cases, overburden its justices with so many cases, and be able to concentrate on what we call the important constitutional precedent-setting decisions, so that when the Supreme Court does speak, it always speaks with what I call like a thunder, that it is setting the law or affirming a policy, and that in all other cases, it should, as a matter of policy, consider the determination of decisions of cases coming from based on the decisions of the Court of Appeals as basically settled, and unless there's clear abuse of discretion, that it should not allow them to go into the marriage, Your Honor. That's my philosophy, Your Honor.
Can you not shorten it somehow?
Oh, yeah. A Supreme... Yes, Your Honor.
Well, it's so hard to digest that. Just like, for example, the ideal of the integrated bar of the Philippines, like no master but law, no guide but conscience, no aim but justice.
Yes, Your Honor. The Supreme Court that serves primarily the needs of justice in this country, in all its aspects, Your Honor.
Well, there's another matter. You were talking about the bar. I don't want to demystify bar top-notchers, but then there are several sectors which propose to abolish the bar. Their idea is to give examinations to the first year students after finishing the first year, and then examinations for the second year, examinations for the third year, and the examinations for the fourth year.
Yes, sir.
In that in that way, well, examinations may be given by the Supreme Court or a committee in charge of that, or by the CHED, or by the Board of Legal Education.
Yes, Your Honor.
In that way, you already eliminate those who don't deserve to be lawyers from the start. But can you imagine when you the results of the bar says that only 15%, 20% pass, and so what happens to the 80%? They're jobless. So that's the idea. So even from the start, just like the what do you call that in college, ICQ. Even from the start, you already eliminate those who do not deserve to be lawyers. What do you say to that idea?
Yes, Your Honor, that would be good, but that means that you must play a very high, a very strong weight on the shoulder of the Legal Education Board, because it's possible, Your Honor, that it is possible that certain law schools are so differently situated that in order to attract students, at least to make their law school at least survive, that they begin to go down on the criteria of what we call academic excellence. I think that's the allure of the bar examinations, Your Honor. It is the hardest government exam being granted, and it usually epitomizes the work, the great intelligence, and the hard work of some of the brightest and most diligent men and women of this country. In other words, it is a mark of excellence. And therefore, if we can translate that, Your Honor, into the law schools, by all means. But that means that being able to accredit the law schools and being able to monitor them and ensure that only the best and the brightest, those who are qualified to enter the legal profession, are allowed to operate. And there's a system of checking this, Your Honor. Yes, that would work, Your Honor. But that means that we would have to close down almost half of the law schools in this country, because some of them are just graduating as bar results would show, more than half of them are graduating.
There are only a few who try to make money out of law schools, but really there is no law schools do not make money.
They
want only the name.
That's right, Your Honor.
But well, one idea would also be to limit the number of law schools.
That's true, Your Honor. I think that's the best.
In Hong Kong, there are very few lawyers, only about 2 or 3. The reason is that there is no law school in Hong Kong.
Yes.
If you want to be a lawyer, you go to London to study law. Only then will you be qualified to.
The same thing in Singapore, Your Honor. There are only 2 law
Yes,
schools,
that's true.
and you cannot open one unless the government says you